The moment the denial hit the docket, the illusion snapped. No press conference, no dramatic announcement, just a cold procedural rejection that landed like a hammer. An emergency appeal filed in desperation, rejected without ceremony, without oral argument, without hesitation. The message was unmistakable. The courts were no longer negotiating with Donald Trump's mythology. They were moving forward with law. This did not feel like a routine setback. You could sense it in the silence that followed. The kind of silence that settles when a room realizes something irreversible has just occurred. Trump's legal team knew it instantly. They didn't lose emotion. They lost time. And in criminal law, time is oxygen. When it disappears, panic follows. What actually happened was not complicated, but it was devastating. A federal appeals court refused to pause criminal proceedings. No stay, no delay, no deference. The immunity argument, the keystone of Trump's entire defense strategy, was treated not as a close question, but as a failed one. Unanimously. That matters. Unanimity is the judicial equivalent of a door slamming shut. It signals to every lower court, every prosecutor, every future panel that this path leads nowhere. This wasn't about politics, it was about classification. The court drew a bright line between official acts and private conduct, and then placed Trump's behavior squarely on the wrong side of it. Efforts to overturn an election, pressure state officials, manipulate electors, incite disruption of congressional certification, none of it qualified as presidential duty. That finding is lethal. Once conduct is deemed private, immunity evaporates. Prosecutors don't have to speculate. They have a roadmap. This is where the narrative breaks from what many people still assume. Trump did not lose one case. He lost the framework that protected him across all cases. Immunity was the shield meant to delay everything until after the election, maybe forever. Without it, the system reverts to normal speed. Speedy trial rules apply. Scheduling orders snap back into place. Judges stop waiting. The clock started ticking immediately. Appeals timelines are not suggestions, they are mandates. When an appellate court rules, trial courts regain authority. Motions resume, witness lists activate. Jury selection planning begins. The difference between theory and reality collapses fast. This is why the response from Trump was not legal, but emotional. Caps lock posts, accusations, threats framed as warnings. He wasn't arguing doctrine. He was lashing out. That's not strategy. That's loss of control. Every outburst revealed the same truth. He understood what the ruling meant. Zoom out, and the pattern is unmistakable. This is not an isolated failure. It is the culmination of a long-running authoritarian playbook colliding with a system that finally refuses to bend, delay, intimidate, delegitimize, overwhelm. Those tactics worked in business disputes. They worked in politics. They do not work when courts document everything. Authoritarian movements rely on one assumption above all others: that institutions will hesitate, that judges will fear backlash, that prosecutors will retreat, that law will flinch when threatened. January 6th shattered that assumption in real time, but accountability lagged. Now the lag is ending. Legally, the consequences are staggering. Conspiracy to defraud the United States is not a symbolic charge. It criminalizes coordinated efforts to obstruct lawful government functions. Conspiracy to obstruct an official proceeding goes directly to the certification of electoral votes. Conspiracy against rights targets interference with citizens' right to have their votes counted. These are structural crimes. They exist to protect democracy itself. Due process is not Trump's enemy here. It is his constraint. Due process requires evidence. Evidence exists: documents, texts, emails, call logs, recordings, video, testimony from his own vice president, his own chief of staff, his own lawyers. This is not circumstantial fog. It is evidentiary density. The collapse of immunity changes everything procedurally. Judges no longer treat Trump as a special category. Motions to delay face skepticism. Threatening rhetoric becomes admissible context. Witness intimidation becomes a live issue. Every post, every statement, every implied threat is preserved, time-stamped, cataloged. Prosecutors don't argue hypotheticals. They present exhibits. The climax is not theatrical. It is methodical. Multiple jurisdictions advancing simultaneously. Federal court in Washington moving toward trial. State prosecution in Georgia waiting its turn with independent facts and recorded evidence. A classified documents case in Florida carrying exposure measured in decades, not headlines. Civil judgments draining financial resources needed for defense. This is pressure from every direction. And pressure changes behavior. Allies reconsider loyalty. Lawyers calculate exposure. Co-conspirators weigh cooperation against indictment. Silence stops being safe. Loyalty stops being protective. The blast radius widens, and everyone inside it knows it. Trump's greatest vulnerability has always been process. He thrives in spectacle, not procedure. Trials strip away theatrics. They reduce narratives to evidence. They force yes or no answers under oath. They do not respond to intimidation. They respond to proof. This is why security escalates. Not because courts fear protests, but because history taught them not to dismiss threats. When a former president frames prosecution as an attack on the nation, it radicalizes followers. Law enforcement prepares accordingly. That preparation is not political. It is operational. Internationally, the signal is just as severe. Allies see a democracy testing its own guardrails under extreme stress. Adversaries watch for hesitation. Stability depends on credibility, and credibility depends on accountability. When accountability activates, it restores trust. When it falters, instability spreads. The next phase is unavoidable. Jury selection transforms abstraction into reality. Witness testimony replaces spin. Cross-examination exposes contradictions. Documents speak when rhetoric collapses. This is where power myths die, not in elections, in courtrooms. There is no scenario where this returns to normal. Even acquittal would not restore the old order. The assumption that presidents are beyond criminal reach is gone, permanently. The judiciary made that clear without shouting. What remains is a choice for the public, to treat this as spectacle or to understand it as a stress test of democratic durability. Missing updates is not neutrality, it is blindness. These moments do not announce themselves twice. Stay alert, follow the filings, watch the timelines, because what unfolds next will not slow down for disbelief, denial, or distraction.